Welcome to Professional Practice Session 101. We are Group 6 from Tutorial 2 and we are going to show you what are the details that solicitors should be taken note of when they are giving undertaking. I am Cheah Jia Sing, the first presenter of the day. Before we dig into the main content, we shall first understand what are the legal meaning of undertaking. It has provided by Abdul Malik Ishan Justice in the case of Madam Pakian Marmalingam and Padang Pengguan, Malaysia. His lordship stated that an undertaking may be described in many ways. Bluntly put, it is an unequivocal declaration of intention addressed to someone and that someone places reliance on it. However, a benefiting party cannot assume everything is an undertaking. There is a considerable difference between a solicitor stating that they will return a phone call by forgetting later and failing to transfer money on completion day when managing a property transaction. For instance, in a conveyancing transaction, it is common for an advocate and solicitor to hold the original title to a property for their client under an undertaking. This original title should be kept safely by the solicitor and only be released upon receipt of the full purchase price. Only by then, purchaser solicitor will pay the full purchase price to the vendor solicitor. In litigation, there are times when solicitors are also called upon to give their undertaking to court for the purpose of fulfilling a particular responsibilities. I will now pass the floor to Yoon Chee to further discuss the nature of undertaking.
Good day, my name is Yoon Chee, and now I will continue the presentations on the nature of undertaking. The solicitor undertaking is usually accepted by another solicitor, the court, and the third party. Failure to fulfill the term of the undertaking will cause the particular solicitor to be liable for professional misconduct and face the disciplinary action. One of the nature of the undertaking is that it does not have to include the word undertake or undertaking. As mentioned in the case of Tan Kao Tia and Tan Ching Hai, and the Tuan taking that Salina and Co. affirmed and another, the court held that the undertaking no need to be in writing and the word undertaking no need to be used. Also, in the case of Ho and Ho Ping Guang and Trico Property Sandiang Berhad and another, the court held that the express word of undertaking is not necessary because the language used and the surrounding circumstances can prove the existence of the undertaking. The next nature of undertaking is it must be given by the solicitor in the capacity as a solicitor, as mentioned in the case of the Tuan Kumar, Jasper, Kwa and Aisha, and Fal Legion Sendiam Berhad and others. In the case of Oriental Bank Berhad and Abdul Razak Raus, the solicitor had given an undertaking in his professional capacity as solicitor to the plaintiff to register the charge, but the charge was not registered in favor of the plaintiff. Hence, the court held that, based on the balance of probability, the solicitor had breached the undertaking because he failed to register the charge in favor of the plaintiff. The third nature of the undertaking is the term of the undertaking must be clear, unqualified, and unequivocal. As mentioned in the case of Tunku Ismail bin Tunku MD Jeva and another, and the Tuan Hisam Sobri and Kadir, the court held that, based on the fact, the solicitor undertaking was clear, unqualified, and unequivocal because the nature and the effect of the undertaking was clearly stated. Also, in the case of T. Damon Darren and Koi Kwan Kim, the court held that the term of the undertaking was clear, unqualified, and unequivocal because it's clearly stated that the solicitor would pay the balance of the purchase money once the transfer of the land was being registered. So these are the natures of the undertaking from me.
I am Yvonne and I will be continue to discuss about the nature of undertaking. An undertaking must be possible to be performed. According to ruling 14.9 sub 2 of the Bar Council ruling, as well as the ruling 23 of the Conveyancing Practice ruling, a solicitor shall not impose or request another solicitor any undertaking which is unreasonable or beyond the control of the solicitor. In the case of Oriental Bank Berhad and Abdul Razak Rose, the court held that an undertaking must be the one which is not impossible ab initio for the solicitor to perform. So what amounts to impossible ab initio? In the case of Goyu Chu and Sokianti, it was held that for an undertaking to be impossible to perform, the improbability must be exist before the agreement. Next, if an undertaking is conditional, the condition must be fulfilled before the undertaking will be enforced. This is stated in the case of Oriental Bank Berhad. Next, In the case of Yoon Chee and Saradwati Devi, the court agreed that the undertaking to give security by the attorney was conditional, because he shall only do this if there is further proceeding were taken. Since there is none, he was not liable for breach of undertaking. Following to discuss is about the disclaimer in email. According to ruling 14.9 sub 3 of the Bar Council ruling, a law firm is prohibited to insert a disclaimer at the bottom of their email so that the undertaking given by the email purporting to bind the firm shall not be valid. So, what kind of disclaimer a law firm can insert in the email? Here is an example.
It shall be noted that the firm is bound by undertaking given by legal assistance, as legal assistance has ostensible authority. In the case of Tunku Ismail Jawa and Tuan Hisham Sabri and Kadel, the court held that an undertaking given by a legal assistant employed by the firm shall bind to the firm. In Bank Kerjasama Rakyat Malaysia Berhad and Tuan Harani Rani and Anika and others, the court held that even an undertaking given by a clerk by the firm is because it was undertaken under his firm name. At the moment, the clerk is actually a representative of the firm. While other nature of undertaking are also important to be noted of, an undertaking can be given by oral or in writing. Once it was given, it cannot be withdrawn from except by consent of the party. Also, the undertaking would not lose its power even the client has passed away, or he had changed the instruction, or even if he decides to change the solicitor. Last but not least, if one party decides to waive the undertaking, it cannot be enforced again.
Moving on, discuss about the enforcement of undertaking. According to Husbandry Law of England, when a solicitor gives his personal undertaking as a solicitor, the undertaking may be enforced summarily in application to the court. It may be enforced against a solicitor notwithstanding that the client has died, has instructed the solicitor not to do so, or has changed his solicitor. Only when the performance of the undertaking has been waived, then the undertaking will not be enforced afterwards. This can be seen in the case of Tan Kao Tia and Tuan Teh Kim Teh. Besides that, according to Section 94 Sub 2 of the Legal Professions Act, a lawyer who has been guilty for any misconduct shall be liable to penalty or punishment, whereby misconduct is defined in subsection 3, para B, which include a breach of duty to the court including to any failure by him to comply any undertaking given to the court. In addition, referring to Ruling 14.9 Sub 1 Sub A of the Bar Council ruling and Ruling 22 of Conveyancing Practice ruling, a failure to honor an undertaking amounts to professional misconduct which could lead to a disciplinary proceeding. Therefore, lawyers shall be prudent before giving any undertaking.
Hi, I'm Jocelyn Yong. I will continue the presentation by expanding on a part of summary jurisdictions. Generally, when the solicitors had given undertakings but failed to perform their undertakings, the court can exercise summary jurisdictions upon the applications by the benefiting party from the undertakings. According to the case of Udao and Capric Lightning, a breach of undertaking would amount to misconduct on the part of solicitor, and it is a case for summary jurisdiction. By referring to the case of Geoffrey Silver and Drake and Thomas Anthony Benz, the summary jurisdiction means that the solicitor cannot avail himself of the advantage of a trial. There shall be no pleadings, no discovery, and no oral evidence without the leave of the court. In some cases, the applicant might not be the client of the solicitor. However, according to the case of S&M Shopping Arcade and Hui Lian Kwong Ting, the court has an inherent jurisdiction to entertain the applications by any person to whom the undertaking has been given and order the undertaking to be performed. According to the case of Tian Hock Tiu and another and Sentosa Advocates and Solicitors, the jurisdiction is even extended to a person who had direct and substantial interest in the subject matter of an undertaking, even if that undertaking is not met to him. Besides, it is important for the court to ascertain that the undertaking was given by a solicitor in his capacity as a solicitor. This can be seen in the case of Tunku Ismail bin Tunku Muhammad Jawa and Anado and Tuan Hisham Shobri and Kadil. The court held that if a solicitor gave an undertaking in his capacity as a solicitor, the court may exercise the summary jurisdictions and order the solicitor to perform his undertaking directly. The undertaking is not necessary to be an undertaking to the court or an undertaking related to the legal proceedings, provided always that it is given in a solicitor's capacity. Next, a court can invoke 8 summary jurisdictions to punish a solicitor, although the misconduct of that solicitor is disclosed during the proceedings. According to the case of Brandon and Spyro, the summary jurisdictions can also be exercised over a solicitor who has ceased to be solicitor on the record. That's all from me. Thank you.
Good day, my name is Izzah, and today I'll be talking on a civil suit for breach of undertaking and also defenses available for the solicitor. So accordingly, if a solicitor breaches the undertaking, they could be held liable under civil suit, specifically under disciplinary jurisdiction. So this disciplinary jurisdiction could be exercised in 2 ways. First, the advocates and the solicitor could be punished by getting struck off the roll, or they can be asked to be a position either to the client or to the opposite party. However, it should be noted that the standard required is so high that the courts have only allowed one defense, and that is defense of mistake. And this is the principle in the case of Richo Kwan Him, also in T. Damodaran. So, if the money is paid to the third parties in breach of undertaking, the court may compel the solicitor to return the money regardless of whether it is recoverable or not. Also in Udal, if the misconduct causes loss, the court may order the solicitor to make good the loss, and the fact that the undertaking was to be performed by a third party such as the solicitor clerk shall not be a defense to the solicitor at all. Generally, there are 2 defenses available to the solicitor. So first is defense of mistake, and second, when the undertaking is impossible to perform. So for defense of mistake, the solicitor must not aware of the extent of the undertaking and it was actually given by mistake. And this defense is applied in rulings and where the court refused to enforce an undertaking against the defendant because the mistake was that the undertaking went further than he intended or was aware of, in as much as he never intended to remove the projecting buttresses. So conversely, in Tunku Ismail, as the court refused to accept this defense because the defendant already knew of the risk coming, yes, the defense of mistake in this case shouldn't be considered, given that the legal assistant in this case took the risk by giving the undertaking when the necessary banker's guarantee has yet to come to issue. When we come to the second defense, where undertaking has become impossible to imply, this defense was considered favorably in the case of VA solicitor. But in this case, the court had held that the lease, which is the subject matter of undertaking, was already forfeited. This defense was also considered in Tunku Ismail. However, the court was in the view that the undertaking was not impossible to perform, given that the banker's guarantee had already could be obtained from any other bank, especially since the vendor had already given back in possession. That's it from me. Thank you.
Before we end our discussion, let us have a fast recap. First, we have discussed nature of undertaking. We have learned that the word undertaking need not to be used. However, undertaking must be given by solicitor in his capacity in a clear, unambiguous and unequivocal manner, and it must be possible to be performed. Also, we shall be noted that undertaking given in the capacity as solicitor to the third party is valid, and any email disclaimer is not allowed. For conditional undertaking, the conditions stipulated must be fulfilled beforehand. Other nature of undertaking includes it can be given in both written and oral forms, it cannot be performed, one is waived, and 3 others. Next, we have learned that the court can ensure undertaking by summary jurisdiction. The purpose is to maintain a disciplinary strength of the solicitor by enforced punishment on such breach. These punishments here includes monetary compensation and restitution of money. Lastly, there are also defense available for the solicitor, which includes mistake and impossible to comply. That's all from us. Thank you for watching.